Question is that the bill be now read a second time. Mr. Souza.
Sir, this bill has the monumental task of reforming Singapore's criminal law. It is the result of an immense effort by the many stakeholders, MinLaw, MHA, the AGC, Law Society, the Criminal Bar, and members of public who provided valuable feedback. The product is a formidable piece of legislation. Sir, today I would like to discuss 6 broad themes underlying the amendments and the discussions leading up to the presentation of this bill in Parliament. The first theme is the protection of victims in vulnerable positions. In particular, vulnerable victims who are unable to defend themselves, victims of abuse within a marriage, and minors who have been victimized by abusive or lewd acts. Clause 83 introduces offences which improve the law's capability to address situations where sustained abuse and neglect results in the unfortunate death of a vulnerable victim. Some of us remember the case of Annie E. Annie was a 26-year-old waitress with intellectual disabilities. She was physically and psychologically abused by her flatmates for 8 months until she died with severe injuries. This law will ensure the perpetrators in a case like Annie E.'s will be dealt with accurately and effectively, matching culpability with an appropriate sentence. Another case, in 2015, the case of Joshua Robinson, surfaced. He was found to have in his possession 5,902 obscene films, 321 of them containing child pornography, featuring children as young as 2 years old. Robinson had even showed a 6-year-old girl an obscene video while her father was training at a gym. Many Singaporeans raised concerns that the sentence of 4 years imprisonment was inadequate. Clause 117 of the bill addresses that. That clause introduces the offence of sexual activity or image in the presence of a minor below 16 years of age. This is relevant to the proposed section 376E(d). It should be supported. During the debate on the Penal Code Amendment Bill in 2007, Ms. Ellen Lee raised the point that the exceptions to marital rape immunity are inadequate to address serious abuse in marriage. In particular, Ms. Lee cited the case of PP against N, where the marital relationship was already highly strained and the husband forcefully dragged her back to their matrimonial home, tied her hands, gagged her, and then raped her. The changes to sections 375, subsection 4 and clause 110B address that and puts into clear focus the victim's interests. This is a bold move and should be supported. I am also glad that Ms. Lee's conscientious voice in 2007 has made an impact in the changes we are discussing today. Many countries talk about the rights of the accused. Yes, that is important, but a good justice system is also victim-focused. Sir, onto another topic within the first theme. Singapore-hosted web pages saw an exponential increase in child pornography content. In 2015, there were 10, but in 2016, there were 211. In the first 10 months of 2017, this number almost doubled to 412. The amendments to this bill improve our law's capability to deter such lewd content and punish the purveyors of it. We must protect our children. They are innocent and must be shielded from depraved and corrupt humans who seek offensive pleasure from such lewd acts. Hence, the proposed sections 377BG to 377BK, which punish purveyors of child pornography or child abuse content, are important and timely. Sir, I move on to the second theme, that is to ensure culpability even where the criminal acts are committed overseas. One key way is to tackle crimes committed through the internet. The proposed section 4B1C does so by specifying that certain offences committed outside Singapore, but which affect Singapore, are punishable as though the act had been carried out in Singapore. This is especially useful for financial crimes which can be committed remotely, with no respect for territorial boundaries. This ensures that the arm of Singapore's law can reach overseas actors who create harm in Singapore. This is key for a highly connected hub such as Singapore. It is an amendment that is needed and welcomed. Sir, I move on to the third theme. The new presumptive minimum sentence is another important feature of this bill. The proposed section 303A of the Criminal Procedure Code in clause 169 introduces more flexibility in sentencing by allowing the court to impose a sentence less than the presumptive minimum sentence if exceptional circumstances made it unjust to impose a first-time offender with the presumptive minimum sentence. At this stage, I should declare that I am a lawyer in private practice and sometimes act as defense counsel in criminal cases. From my experience, it is good to give our judges the discretion to impose accurate sentences. This may involve, at times, lighter sentences where there are strong mitigating factors which put the offender's acts in perspective. Allowing a judge to mete out a lower sentence, even lower than the presumptive minimum, could prove very useful where an offender is quite clearly on the lower spectrum of the culpability scale. It makes for more accurate justice. However, I do have a clarification to ask. In the new subsection 4, it says that in any written law, unless the context requires otherwise, a reference to a mandatory minimum sentence of imprisonment shall include a reference to a presumptive minimum sentence. Could the Minister elaborate on whether such a rationale applies to all existing regulatory and criminal laws, or whether it is strictly restricted to only the laws contained in the Penal Code? For example, how would subsection 4 apply to the Misuse of Drugs Act, which already has a carefully calibrated deterrent rehabilitation regime through the availability of the Drug Rehabilitation Centre at one extreme and the long-term imprisonments 1 and 2 options at the other extreme? In short, sir, presumptive minimum sentences will have the advantage of creating some broad consistency in sentences across courtrooms and across cases, but allows much needed flexibility where the merits of the case justify a lower sentence. Such flexibility allows for more accurate justice. Sir, I move on to my fourth theme. While it is good and necessary to carry out an extensive review of our criminal laws every 12 years or so, would the Ministry of Home Affairs and MinLaw consider creating a set of legal tools which could deal with morphing criminal threats of the future? In a world where technology progresses so rapidly, the potential criminal activities and their modus operandi may be morphing so quickly that even though we have a robust new criminal law framework now, the law may still not be wide enough to address criminal methodologies of the future. Therefore, would MHA and MinLaw consider the suggestion to introduce a schedule or the possibility for subsidiary legislation through which the Minister can respond quickly to the morphing criminal phenomenon without needing to come to Parliament? For example, in the Misuse of Drugs Act, the Minister does not need to come to Parliament to update the list of drugs, especially new psychoactive drugs. In this way, the law addressing the harms of drugs is flexible, versatile, and able to respond quickly to the threat. An example of what could be done for a penal code provision is by introducing a schedule for section 409 of the Penal Code. It was held by the Singapore Court of Appeal in the 2018 case of public prosecutor against Lam Leng Hung and Kong Hee and others that the provision contained in section 409 on criminal breach of trust by an agent does not cover key officers of a charity and officers of a society. If there was a mechanism for a readily amendable schedule or subsidiary legislation, and the original offence in the primary legislation was broad enough and consistent with Parliament's intention to encompass such a situation, then rather than having to come to Parliament to amend a provision to plug loopholes, the Minister could expand on the limbs of an existing provision to tighten the law through a schedule or subsidiary legislation. While this cannot apply retrospectively, it would be a quick and efficient way to plug loopholes for future cases. Could the Ministry of Home Affairs and MinLaw consider this suggestion, please? My fifth theme covers Section 377A. Sir, I support the government's decision to retain the provision. Since speaking on the topic in Parliament in 2007, I have followed the debate in other countries and studied the multiple legal challenges in various jurisdictions which seek to redefine marriage, gender, adoption rights, spousal rights, and what is taught in schools. This has caused me to believe that retaining a provision such as Section 377A, even if it is unenforced, continues to be a good approach for our country. The provision remains relevant and necessary. Sir, I am of the view that the environment the traditional family unit offers to children supports the state in creating the best environment for the upbringing of children. This environment should be protected. We should build it up and not tear it down. Therefore, my views expressed in 2007 have not changed. Sir, my sixth theme covers Section 309. Clause 89 repeals Section 309, the offence of attempted suicide. I have concerns regarding its repeal. Yes, attempted suicide is an issue which must be addressed with great sensitivity, and the topic must be respected with all the attendant empathy it so clearly deserves. However, I have looked at the Ministry's arguments for repealing Section 309, and I hold a different view. Section 309 should be retained. In a way, retaining it is the more compassionate approach because, in my view, preserving the provision will save more lives. Retention of the provision has a further advantage. It prevents euthanasia from making its way to our shores. Sir, do I believe we should help members of our society who are contemplating suicide? Absolutely. Do I think we should enforce Section 309 against people who attempt suicide? In most cases, no. But keeping the provision is still of immense value. Why? I humbly submit that there are 6 reasons. First, because it sends a normative signal that taking one's life is not the answer to life's problems, to the extent that the law prohibits it. Second, the repeal of Section 309 may send the signal that taking one's life is acceptable to broader society, when in my view, that is not society's thinking. 3, all the attendant treatment, support, care, and counseling can be provided while still retaining the provision. Indeed, when this happens, society would benefit from the deterrent effect of the law. This means that the law would help deter some future suicides in society, while at the same time, the people who need the counseling and care are able to receive it. I cite the inspiring words of a courageous young lady who wrote a forum-page letter in the Straits Times in February 2019. I quote her, quote, "As someone who overcame suicide and is now a passionate advocate for the sanctity of life, I am sad to see suicide being decriminalized in our nation. Suicide is truly a multifaceted and complex issue, and the law should not be excluded from having a deterrent effect on people who see death as the only option in their difficult circumstances. I gave up the idea of further suicide attempts after police officers gently reminded me that attempting suicide was an offense. There was no need for the authorities to restrain or prosecute me, for I was cooperative and clearly in distress. In recent years, I managed to persuade a young foreigner from killing herself just by informing her the offensive nature of suicide in our nation. Human life is sacred and should not be violated, not even by ourselves. She goes on, the decriminalization of suicide perpetuates the erroneous message of my body, my choice. When it is no longer mandatory to report a suicide attempt, people will stop reporting it as it is not a crime. Unquote. Ms. Ho Lei Ping. Writing that and putting a name to it takes immense courage, and I respect that. There is further value in that story. That real-life story shared by Ms. Ho displays why the presence of Sections 305 and 306 do not cure the concerns over the decriminalization of attempted suicide. Fourth reason, I agree with the Ministry that the stigma against those suffering from mental health should be removed. Indeed, I have spoken up in Parliament about removing such a stigma and increasing community support for those suffering from mental illness in 2018 and 2019. Such a stigma is not fair. We should not hold mental illness against the person who has it. But the removal of Section 309 does not need to be part of that destigmatization exercise. Why? Because there is a risk that the number of suicides will increase if there is no provision to deter the act. Broader society will have no legal deterrent, and those attempting suicide may consider the absence of a prohibition as a license to attempt the act. If that were to happen, society loses, and we could see an increase in the number of suicides in future. I feel duty-bound to articulate that concern in this House. My fifth reason, there should be mandatory reporting of suicide attempts. Yet, this bill removes the requirement for mandatory reporting. This, in my view, should be seriously reconsidered, since removing the requirement for the mandatory reporting of an attempted suicide removes one means, a crucial means, by which the suicidal person can get the professional help he or she needs. Sixth, the retention of Section 309 consolidates the moral position against euthanasia. For the record, sir, I support laws that outlaw euthanasia, for I believe that an innocent life is as precious through sufferings as it is through joys. Therefore, for all the 6 reasons above, I ask the Ministry to seriously reconsider whether it wants to repeal Section 309. If the Ministry wishes to proceed with the repeal, then I ask that a detailed study of the number of suicides following the repeal be undertaken. If the number of suicides in Singapore increases following repeal when compared to pre-repeal numbers, I ask that the Ministry consider reintroducing a provision similar to Section 309 back into the Penal Code. For such a detailed study to be meaningful, mandatory reporting should be reintroduced. It should not be abolished. Otherwise, the study may be inaccurate. In essence, sir, I urge the government to closely examine its decision to decriminalize the offence of attempted suicide and closely monitor the impact that it has on our society. My concerns regarding the abolition of Section 309 do not dilute in any way my strong support for the other excellent facets of this bill. After all, the other amendments seek to protect vulnerable victims, ensure our muscular law reaches perpetrators who seek to do Singapore harm from beyond our shores, retains Section 377A, and introduces a sentencing framework which allows for the deployment of more accurate justice. Those are strong and commendable initiatives worthy of support. Thank you.